Hi guys, in the last video I'm so sorry it was suddenly cut because of certain reasons and it could not be the last video. This is definitely the last video and it will be a very short video. In the previous video we were discussing about the cognizable and non-cognizable offenses and a small part on criminal liability which arises from 7 years, and in this video we will be starting from doctrine of autrefois acquit and autrefois convict. I am pronouncing this autrefois, though it is traditionally known as autrefois acquit, autrefois convict, because I don't want you to make a spelling mistake in this word. It's auter in the second word and autre in the first part. Acquit, autrefois, and convict, autrefois. Right? Let's understand what is the meaning of this doctrine. Now, this doctrine states that if a person is tried and acquitted or convicted for an offense, he or she cannot be tried again for the same offense or on the same facts. Okay, this is quite obvious, but this is also important legal doctrine. If a person accused of a crime is being convicted for perhaps thievery, and the person is imprisoned for 2 years, suppose, the person shall not be re-imprisoned on the same grounds, on the basis of the same, um, you know, what is it called? Same offense. The person won't be convicted for the same thing again and again. This prevents the accused, this protects the accused rights from being repetitively punished. And this has been included in Article 20, Part 2 of the Indian Constitution and Section 300 of CRPC. This also stipulates that the accused has a right against self incrimination. In our last video, we discussed in details the meaning of the word self incrimination. I will explain once again. Incrimination means no person accused of an offense shall be compelled to be a witness against himself. So, if I have done something, suppose I am accused of a crime. Now, I won't be pressurized by the court authorities to confess that yes, I have done something. This confession should be spontaneous, should be based on my voluntary will. If I confess, but the court should not pressurize me to accept it. That's the essence of this doctrine, and this has been included in Article 20 Part 3 of the Constitution. 20 Part 2, what is there in it? The doctrine of autrefois acquit and autrefois convict. And in Article 20 Part 3, the accused has a right against self incrimination. I cannot be forced to be a witness against my will. Function and role of the police. Now, with respect to this, you have to remember two main acts. First of all, the Police Act 1861. Now, it was enacted when India was a colony, and it used to represent those Indians who used to represent the colonial government. It describes the structure and function of police in general as an instrument of detection and prevention of crime. Now, in the state level, we have the Director General of Police, and below the state, in the districts, we have the District Superintendent of Police, the DSP. Other important designations are District Magistrate and District Collector. District Collector refers to those administrative officers, often, what is it called? The IAS officers, they're often known as the district collectors. And every police officer, except for the Inspector General, Deputy Inspector General, and District Superintendent, they receive a empowering certificate from the state which specifies their powers, functions, and privileges. By virtue of this certificate, they can exercise their vast powers to prevent and detect crimes, to maintain order, etc. And in the lines of the Police Act 1861, recently, after the independence of India, we had enacted the Police Act of 1949 along the lines of the Police Act. And Section 23 of the Police Act, it states the duty of the police officer. First of all, to collect and communicate intelligence, as in various informations affecting public peace. Secondly, to prevent the commission of offences and other nuisance. Often there are certain rallies which are based on nothing, just aim to hamper the peace of the state. Such things has to be prevented by the police. Obviously, a peaceful, meaningful protest, preventing that is not the job of the police, but nuisance should be prevented, and that is done by the police. And also the commission of offences are prevented by them. Offenders has to be prosecuted. And the last point is that the police has the right to apprehend those persons for whose apprehension sufficient grounds exist. Now, what this basically means is that those persons who are guilty, the person is supposed to be prosecuted no matter what. That's the duty of the police officer. And if you have a better explanation of this point, you can definitely write in the chat. I will also know. Let's move on to the next part. The criminal investigation and FIR. What is an FIR? I explained the first information report. And what is the definition? Note this definition very carefully, guys. FIR refers to the information recorded by the police officer on duty, which relates to the information about the commission of a cognizable offense. Cognizable offenses obviously relates to the more serious offenses. Obviously, suppose if my suppose I have a garden and I have kept various exotic plants in my garden. Suppose one of those plants are being stolen by a neighborhood person. I cannot file an FIR. Yes, I can go to the police to get some help, but there is no FIR in such petty things. FIR has to be filed in the more serious offences, the cognizable offences. What are the cognizable offences? These are punishable for more than 3 years. We did it in the details in the last video. You should not forget. Okay. And this FIR can be filed by either the victim or the representative of the victim. Just a second, guys. Okay. The representative of the aggrieved person, he or she can also file the FIR on behalf of the victim. And the police is obviously duty bound under section 154 to file the FIR. And the FIR has to be filed in the police station of the concerned area. It can be written or verbal, and it has to be signed by the person who has filed the FIR, either the victim or the representative of the victim, any other person. And what happens? It has to be filed by the officer in charge or the assistant sub-inspector of the police station. And our legal system has also given us provisions of what to do if the police officer refuses to file the FIR. We can send our FIR via post directly to the superintendent of police. We don't have to give it to the officer in charge, who is obviously junior than the superintendent of police. Directly we can post it to the superintendent of police, and this provision is given in Article 154 Part 3. Study this. Now, Section 154 of CRPC also provides the process of investigation, what we have to do. FIR is not a substantive piece of evidence. In a court, we can't say that I have filed this FIR, so that's the proof that the offense was in fact committed. I have to prove the FIR, that I indeed had filed the FIR because of certain malpractices and corruption. These provisions are laid down. Then it has to be in writing. It can also be verbal, and the signature of the informant must be obtained. The police gives a photocopy of this complaint to the complainant, the person who has filed the complaint, and if the police officer refuses this provision, you're right about this provision, the aggrieved person can send the information directly to the superintendent of police by post. And immediately after the commission of the offense, the FIR has to be filed, not after 6 months. And a telephonic conversation which is disclosing the commission of an offense, this can also be treated as an FIR. This goes section 154 of CRPC. Section 155 of CRPC relates to non-cognizable offenses. As I was discussing, the more petty offenses which are to be treated as private criminal wrongs. The officer enters the substance of the accusation in a book. Okay. There is no further duty of the police officer unless the magistrate directs. Who is the magistrate? Don't get confused by this. Magistrate is simply the nearest judge of this lowest ranked court, not the high court judge or district court judge. In a civil case, it's the munsif judge, and in the case of a criminal case, it's the second class judicial magistrate, perhaps. And also, if a criminal case has both cognizable or serious cases and non-cognizable or less serious cases, then the entire case will be treated as cognizable. It will be deemed serious because it has serious issues here. Now, congratulations, we have almost completed the chapter. I know it's a huge chapter. Please don't lose your enthusiasm. Now, there are other courts in India. Because the traditional law courts are so burdened with increasing litigation nowadays, there are other courts. Now, I have listed down the 3 reasons. First of all, it governs specific areas of law, like, say, the environmental area or the income tax area. It governs these specific areas, and it brings efficiency by lowering the burden on courts. There are so many cases that the traditional law courts in the hierarchy are extremely burdened by cases. And the third thing is that it provides a quick relief to the parties of the dispute. There are certain serious things also. Sometimes people are arrested. In those instances, they need quick relief, and that quick relief is given by the other courts in India, the tribunals. Let's see the examples of these courts. First of all, the Motor Accident Claims Tribunal, MACT. Motor Accident Claims Tribunal. Write the full forms in your copy. I want you to make notes along with me, please. Then the Rent Control Tribunal. Third, the Railway Claims Tribunal. Fourth, Debt Recovery Tribunal, DRT. Income Tax Appellate Tribunal, ITAT. You should not be confused regarding all these different things. Now, sometimes these are not even treated as tribunals. These are other courts in India, because there is a separate area in your textbook on tribunals. Alright, then NGT, National Green Tribunal. This particular tribunal relates to all the environmental things. National Green Tribunal. These are the examples of the other courts. Nothing else is there, guys. The Family Courts Act of 1984. And really, guys, I don't need to do this again. Go check out my channel. I have a detailed video on the family justice system posted right some days before. Check it out. I've explained in great detail about the Family Courts Act, the different things about it, and what happens in a family court. Emphasis is on non-adversarial method of resolving family disputes. Process which is not really formal, not really open to public. It's confidential. Obviously, a family don't want its internal dynamics to be shown to all the people around. So there is an emphasis on confidential method of resolving family disputes. Speedy and adversarial method. Speedy and non-adversarial method of resolving the disputes. That's it. There is nothing else on the family courts. You can see it in my video. Please go and check it out. Then we have Administrative Tribunals. Administrative Tribunals Act of 1985. It was enacted by the Indian Parliament. It came into force in July 1985. This date is important. 1985, July 1985, the Parliament enacted the Administrative Tribunals Act. Now, when we did the other courts, why did I say that you should not treat this as tribunals? Because we already have a different subsection on tribunals. Okay, now these administrative tribunals are involved in adjudication of disputes of the recruitment and conditions of service of persons appointed to the public services of the state or other posts perhaps. But all these things relates to the union government. Let me re-explain this part a little more clearly. There are people who are appointed to the services of the state. Okay, of various tribunals perhaps, and these people obviously have certain disputes regarding their service conditions, perks, allowances. All these disputes related to the employees of the central government are settled in the administrative tribunals. This is the definition given in the textbook. And the Central Administrative Tribunals, in short, I've written CAT, it was established in November 1985 in all these different states: Delhi, Mumbai, Calcutta, and Allahabad. In all these four different states, CAT was established in this particular date, in November 1985, pursuant to the Administrative Tribunals Act of 1985. Alright, now there are 17 benches and 33 division benches of the Central Administrative Tribunals. Now, in these benches, only one judge decides issues. And what is a division bench? A division bench is such a bench of the courts in which more than one person acts as a judge. Suppose there are two judge bench, three judge bench, as many as 13 judge bench are also there in central administrative tribunals and also in other courts like Supreme Court. Very crucial cases are decided by a division bench. Okay. Then Article 323A was amended by the 42nd Amendment Act. Why is it important with regard to the Central Administrative Tribunals? Because Article 323A, this amendment to this article, it has proposed that apart from the central government employees, the Government of India has notified 45 other institutions which can come within the dispute settlement mechanisms of the Central Administrative Tribunal. There are certain organizations in India, perhaps say, what is it called, ISRO. I'm not going to say some specific names because I'm not really sure, but there are certain institutions which are treated as government institutions. I think ISRO is a pretty good example too, based on science research and all. It is almost affiliated to the government. In fact, it's a government organization. So such disputes of the central government employees are settled by the CAT. It's not possible for all of them to run to the Supreme Court to decide all the issues. Right? Now, this CAT settlements cannot apply to the parliamentary forces. No, not parliamentary, the paramilitary forces. Paramilitary means they're not really the military. They are, you can call it the semi-military. They are equipped with weapons, but they are not as sophisticated and as strong as the army. Then armed forces, the army people also cannot approach the CATs because they have their own courts. Then officers and employees of the Supreme Court, the judges or the other employees, even in the minor tasks, they also cannot approach the CAT. Then secretariat staff, houses of parliament, both the houses of the parliament, both the Lok Sabha and the Rajya Sabha, they cannot approach the CAT. Or the secretariat of the state legislative assemblies. The legislative assemblies we have Lok Sabha and Rajya Sabha in the union level, we also have certain representatives at the state and the union territory levels. They also cannot approach the CAT. The chairman of the CAT is a sitting or retired judge of the High Court. Don't write Supreme Court, it's a High Court. And the Central Administrative Tribunal, it also consists of one chairman, 16 vice chairmen, and 49 members. Now, the employees and the chairman, vice chairman, they are also working in the Central Administrative Tribunal. They also can have their own disputes. What happens here? Look at that. Their disputes are settled in accordance to the Central Administrative Tribunal's rule of 1985. Okay? So, with this, we come to an end to this chapter on judiciary, and we finally come to an end to your syllabus on legal studies. I can make a video on the boxes if you want, and definitely check out the other videos on my channel. Thank you so much for seeing my videos, and if you need anything, kindly do mention in the chat box. I will definitely try to make videos. Okay, thank you.